Hi, and welcome. Today we're going to cover everything there is that you might need to know about dividing your pension, specifically your Illinois pension plan and divorce. And of course, when I say everything, that's not entirely correct because you would have no need to hire an attorney. The real reason for having to hire an attorney is that these are much more complicated issues than they seem at first, and you want somebody with a lot of background in negotiating these issues and understanding them to guide you. A little bit about me and why you should listen to me at all. I'll give you a few seconds just to read this yourself. I've been practicing for quite a while in the area of dividing retirement and pension plans, including federal plans and Illinois state plans. And I practice out of Chicago, Illinois. So first, what do we have to protect? In most divorces, the public pension is the largest or the second largest asset in nearly every single divorce case. Here we list the most common types of Illinois public pensions: IMRF, TRS, police, firefighter pensions, and so on. If you or your spouse are members in one of these or more than one of these, you should continue to watch this program. What are the key considerations? And here is a short list of what to keep in mind. One, your pension is marital property. Marital property gets divided in a divorce. Uh-oh. Your pension is income. Income is relevant to support. Now, those two ideas seem conflicted, and perhaps it looks like the pension might get double counted. We'll talk about that more later. Your pension is a defined benefit plan, but it is not subject to ERISA. A defined benefit plan is one that pays you a monthly pension or annuity, typically for the rest of the member's life. But it is not subject to ERISA, which is the Employee Income Retirement Savings Act. It's a federal law to control how retirement pension plans like that are defined benefit plans, are run and how they can be divided. And this is important that you remember that an Illinois pension plan is not subject to ERISA. So if you see language that a lawyer is preparing in your case and it's mentioning ERISA, there's a problem. You might know more about your pension plan than your attorney or the judge. One, it is your pension plan. You tend to be pretty proud of having it and you're counting on relying on it. Two, you're listening to me and watching this. And three, this is really boring for people that just don't have the patience and don't have interest in such plans. Ironically, most judges, actually all judges in Illinois, do have a similar plan, so they should listen as well. You can settle on nearly any terms you want to settle. So think about the possibilities, such as a buyout, offset with other assets. We'll talk about that more later. The pension is divided as any other property. The division is final upon divorce. So what can happen? Events after divorce do not matter, right? Remarry. Your spouse, former spouse, remarries somebody super wealthy. They shouldn't have my pension. Nope, it's final on divorce. You get sick. I need the money more. I can't make any other money. The former spouse won the lottery. It doesn't matter. The division of property, including pension, is final upon divorce. But pension is income used for support, maintenance, alimony to the spouse, pre and post decree. Okay, so pre decree, that means before the divorce is finalized, you're going to be maintenance will be determined based on your incomes. And if you're already getting your pension, then it is included in your income. After divorce, you've retired. The pension changes your income. You're no longer receiving your wages, and now you're just getting a pension. The pension then is looked at as income. And it may affect, if your maintenance is modifiable, how much you have to pay. Maybe you don't have to pay anymore, but maybe you still have to continue paying. Your only income but ex-spouse's property. Now, this is a common complaint you'll have from members, people in your position that have earned that pension. This pension after my retirement is my only income. And if my spouse perhaps is younger, can earn an income from another source, but I have to share it because you said that property is final. Not fair. Okay. Without going into fair or not, you may be correct, but that is exactly how it is. But what if I change jobs? I want you to hold this in the back of your head only because we're going to discuss later how the marital portion is calculated. And that, of course, determines how much the other spouse is going to get from your pension. And there is an increase as you continue working after the divorce, but not if you change jobs and join a different pension fund. Okay, that aside for now. When to work on your pension relative to the divorce, after your breakup, but before the divorce. At this stage, you are negotiating settlement, trading off assets or support, which includes your pension. Consider a buyout or a trade off. When the settlement agreement is being drafted, hopefully by an attorney, remember to always write what you mean and understand what you write. For instance, an actuary will be hired to value the pension fund, and that value is what's going to be divided. Or we are going to use the Hunt formula, which we'll discuss a little more later. The alternate payee, your former spouse, will receive cost of living adjustments, COLA, or will not. The middle portion will be calculated including permissive service. Find out what permissive service is first. Have a financial expert estimate what you will be giving up. What is that present value of what you will be giving up, just for your information? Then the QILDRO and after. So now you've been divorced, you've determined that a QILDRO is necessary to divide up your pension. Make certain that the QILDRO follows the language of the judgment and plan your retirement accordingly. Maybe change jobs. Again, based on that formula that we're about to discuss, it might be in your interest to change jobs. It might not be in the cards. That depends. Definitely invest what you can to make up some of the difference of what you will be losing. Consider the trade-off and buyout. You keep the house, I keep the pension. What is the value of the pension? An example. Spouse is 50 years at divorce and will be 62 when the pension starts. Her share of the pension is $1,000 per month. Okay? The rate of return that you could expect on an investment, let's say, is 5% annually. The value of the pension to her is about $100,000. That means she would need about $100,000 right now to invest so that in 12 years she can guarantee about $1,000 a month for the rest of her life. Now, if she's able to invest the money at 8% a year interest, then she'll only need about $55,000. But if rate of return isn't that good, at 2%, she'll need about $200,000 to guarantee that same $1,000 for the rest of her life. What is the actual value? The alternate payee, the other spouse, is to receive the actual value of the years during the marriage. That's one method of calculating the marital portion. Example, member worked for 10 years before the marriage, 20 years during the marriage, and 10 years after the marriage. The question is, what would be the monthly pension had only the 20 years during the marriage been worked? We need an actuary to calculate this. You can calculate it perhaps in some pension plans relatively easily yourself, or a plan administrator might do it for you. Other method of calculating in Illinois is called the Hunt formula because it is based upon a case of marriage of Hunt. It is a common formula to be used for dividing pensions throughout the United States. The policy behind the Hunt formula is that the later years that result in a higher pension could not be possible without the earlier marital years. So your pension is typically, in most public pensions, figured based upon the earning rate in your last few years of employment, which is the higher rate. And that higher rate would not be possible, would not occur if not for those earlier years that were earned during the marriage. That's why there's an increase to the marital portion for those later years, even though they are after the divorce was final. And again, what if you change jobs? So if you were working in the public sector and you're working for the police or fire department, or various other agencies, municipal, and so forth, and then say you get a consulting job somewhere, and a security company or whatnot, and they offer you a pension plan, a private pension plan, an ERISA pension plan perhaps, or a 401k. Of course, they're offering you the job and those perks because of the experience you had, yet our policy doesn't reach that, meaning the former spouse has no interest in it. Okay, now let's go over an example of the Hunt formula. Now, a member that works for 10 years before the marriage, 20 years during the marriage, and 10 years after the marriage will get $5,000 per month at retirement. And the spouse is to receive 50% of the marital portion calculated using the Hunt formula. So here's the formula: 20 divided by 40, right? Because we have 20 years during the marriage, divided by 40, which is the total time that you've participated in the pension fund, multiplied by the benefit, 5,000, and then we multiply that by 0.5 or divided by 2 to determine half of the marital portion. So you can see that the outcome here is $1,250 of that 5,000 goes to the alternate payee, the former spouse. Okay, that final 5,000 we know would have been lower had the member not worked as long as the member has worked, and so the former spouse is benefiting from the non-marital years of work, as we discussed. Other issues: COLA, partial refunds, permissive service, etc. Cost of living adjustment. COLA is not a given, but it is likely to be given, and that if parties are arguing in court whether it should be or should not be included in what the former spouse gets, it is more likely in Illinois that the former spouse will receive COLA on his or her share, right, the non-member. And the reasoning or policy behind it is simply that whatever you get the interest on it. If it's a savings account or it's a house that appreciates. Partial refunds are typically partial refunds of surviving spouse annuity contributions. So, you paid into this pot, that's contributions that are going to be used to make your pension payments, but you also paid into another pot that in the event you have an eligible spouse, and typically it's somebody that you've been married to for at least 1 year before retirement. In the event of your death, that person is going to get, in most pension plans, 50% of what you got for the rest of his or her life. Okay, so if you do not have an eligible spouse, when you retire, you're going to get those contributions back. Now, there are other types of partial refunds like an overpayment. Should the former spouse get a share of the overpayment? I mean, if that overpayment is due to payments made all after the divorce, there's an argument that the alternate payee should not receive those. Um, Early retirement option refund, right? The state was going to fund early retirement option and then turned out that they couldn't and they returned the members' contributions. Well, when were those contributions made? They were made entirely not during the marriage. There's a good argument for why the alternate payee should not receive a share of those monies. Permissive service typically is sick days. So sick days that were unused and then rolled into the pension fund. And there's probably a good chance that some of those days were, in fact, not used from the marriage. Now, what if there's an enhancement because of a formula upgrade that you paid for? Well, when was it paid for, right? Again, should the alternate payee have a benefit of something that was paid with non-marital funds, after the marriage or before the marriage? Or what about if the years were military years or years in another pension fund that were worked before the marriage? Arguably, that should not be included. And if it is included and you paid something, then arguably the alternate payee should contribute whatever you paid for that time to be included. Some relevant legal concepts to what we're talking about. Orders after 30 days are considered final. I mean, they're final, everybody will tell you the moment the judge signs it, but really those 30 days are super final, meaning you can't appeal it, for instance, to a higher court, an order after 30 days. And a QILDRO, I wrote it like with order there, but it is an order, okay? So it is much more difficult to change after 30 days. And also remember that the judgment controls everything. Okay? If the judgment did not exclude something, it's included. If the language is too general, doesn't talk about COLA at all, the alternate payee is most likely getting the COLA. Be specific. Right? So, always think of protecting something that's valuable in a pension is very valuable. The Federal Reserve data from 2020 and 2021 census and from usafacts.org, published on November 15, 23, their analysis demonstrates the great value of a pension. And here you can see the percentage of retirees with a pension, okay? Retirees with a pension are just less than 60%, okay? You guys, you have pensions because you're listening to this, so you have pensions. What about non-retirees with pensions? People that are in a workforce, about 20%, only 20%. So they're going to retire if they're married to somebody that is older and has a pension. Boy, how many people have no retirement? Of all people, it looks about 47, 48%. And very importantly, the percentage of household wealth, all your household wealth, a pension is somewhere around 35% of all of a household's wealth. Pretty important. So be educated. Reach out to me with any questions you might have. And make sure that whoever you're dealing with knows about your most important or second most important asset in the event of a divorce. Thank you for listening.